Hi everyone, my name is Sienna Wiltshire and today I'm going to be talking about some key terms and concepts related to work health and safety. When it comes to statute and common law, there are many factors that set them apart. Common law is reactive, legal action is taken after the incident, and it already assumes that duty of care exists. Whereas statute law is preventative, implemented before possible injury occurs, and it explains how to meet your duty of care. Statute and common law operate side by side, interacting and influencing each other. If there is a conflict between them, statute law, or legislation, prevails over common law. Under common law, legal action can only be taken after injury or damage occurs, whereas statute law can attract many sanctions and penalties before injury or damage occurs. In the context of work health and safety, a standard is a form of guidance document available to employers and other obligation holders that can be used to control particular health hazards. The two types of standards relating to health and safety are national standards and Australian standards. Standards should be adopted and considered as a bare minimum standard to be achieved. If a standard is listed in legislation, it becomes law. National standards, also known as Australian safety standards, provide technical information, guidance and advice on different areas of safety and health, and are developed by Safe Work Australia. All regulators are expected to adopt the national standards in their health and safety regulations. Australian standards are developed by Standards Australia as well as by committees made up of technical experts, industry professionals, academics, government representatives, and community experts. It is important to note that Standards Australia is not an enforcement or regulatory agency and therefore cannot take action against a person with an OHS duty for not complying with Australian standards. An example for standards is the standards of PCBUs to ensure, as far as reasonably practicable, that the health and safety of others is not put at risk in the workplace. Hammurabi was the sixth king of the Amorite dynasty of Old Babylon from approximately 1686 to 1720 before Christ. The Code of Hammurabi is an engraved black pillar containing 3,600 lines depicting the kings receiving the law from the sun god and god of justice. The code is significant as it was the first time recorded in history that laws have been written down. The Code of Hammurabi is noteworthy for another reason. It sets in place a system of law that is public and specific, that all members of the community, if not equal to the law, have at least assured resource to the law. This is significant because subsequent developing civilizations have always struggled against social system. Hammurabi's code is thought to have established the principle innocent until proven guilty. Provisions of allowable fees for medical practitioners and damages for injuries are some of the provisions that this collection of laws rules. Some of the provisions illustrate the primitive retributive justice of the time. It confers for widows, orphans, and injured or helpless people. The laws contain a kernel of humanity. Prior to the Robbins Report, early Australian OHS legislation tended to focus solely on factories and did not consider other workplaces, and even these factory acts focused on working hours and conditions of machinery. This legislation used what is known as the command and control approach, which heavily relies on inspectors and officers to report these issues. Robbins' core concept was the key. Robbins' core concept was that Robbins' key concept was that work, rather than the workplace, was the key determinant of risk. This meant that its principles could apply to anywhere that work was done. In his words, the risk now lies with those who create the risks and those who work with them. A code of practice provides detailed information on how you can achieve the standards required under the work health and safety law. Codes of practice do not replace the law, but can help you understand what you need to do to comply with specific regulations and provide a healthy and safe workplace. An example of a code of practice is reading manuals and instructions so injuries can be avoided when operating heavy machinery. Reasonably practicable is what is realistically able to be done to ensure health and safety and reduce risks in particular situations, while taking into account and weighing up all relevant matters. There are 5 factors to reasonably practicable. The first one is the likelihood of the risk or hazard concerned occurring. The second factor is the degree of harm that might result from the hazard or risk, or the consequence. The third factor is what the person concerned knows about the hazard or risk and ways of eliminating or minimising the risk. The fourth factor is the availability and suitability of ways to eliminate or minimise the risk. And the fifth is the cost associated with the available ways of eliminating or minimising the risk, including whether the cost is grossly disproportionate to the risk. An example of that one is you wouldn't spend $1 million on replacing all paper envelopes with new ones that eliminate or limit paper cuts, as the risk is not great. A good way to remember the 5 areas is with an analogy. Lucy has kiwis with cake, which stands for likelihood, harm, knowledge, ways, and cost. PCBU stands for a person conducting a business or undertaking and is a senior executive who makes or participates in making decisions that affect the whole or substantial part of the business or undertaking. There are 3 kinds of PCBUs, which include an officer with the meaning of Section 9 of the Corporations Act, other than a partner in a partnership, an officer of the Crown, and an officer of public authority. Officers of a PCBU with a duty or obligation under the WHS Act must exercise due diligence to ensure that the PCBU complies with that duty or obligation. They must do what is reasonably practicable. PCBU is a broad concept that extends beyond the traditional employer and employee relationship to include all types of modern working environments. Due diligence means taking every precaution that is reasonable in the circumstances to protect the health, safety, and welfare of all workers and others who could be put at risk from work carried out as a part of the business or undertaking. Officers will have an understanding to manage the health and safety risks. Harmonisation refers to the Council of Australian Governments signing an intergovernmental agreement for regulatory and operational reform in occupational health and safety to harmonise work and safety laws in Australia. The agreement formally committed all states, territories and the Commonwealth to work together to develop and adopt new work health and safety legislation and guidance materials for Australia. I believe harmonisation has the potential to be beneficial if all states agree to work together to develop this new work health and safety legislation, as it would show that we are united as a country and that all states have a cohesive approach towards WHS matters. Harm is defined in the Public Health Act to include activities that may have adverse impacts and effects on a person's physical or psychological well-being, whether it be long-term or immediate. Some examples of harms include working with chemicals, working with electricity, workplace bullying, harassment or violence, working at heights, and heavy machinery. Thank you so much for taking the time to view my presentation. I hope I have taught you some key terms and concepts related to work health and safety. Have a great night. And these are my references.